Order doctrine is interpreted, quote, with the utmost strictness in criminal cases, end quote. 489 U.S. 794, 799, 1989, cleaned up. The Midland Asphalt Court emphasized that criminal collateral orders that are based on, quote, a right not to be tried, end quote, must, quote, rest upon an explicit statutory or constitutional guarantee that trial will not occur, end quote. Singling out the double jeopardy clause and the speech or debate clause. 489 U.S. at 801, emphasis added. Former President Trump does not raise a straightforward claim under the double jeopardy clause, but instead relies on the impeachment judgment clause and what he calls, quote, double jeopardy principles, end quote. Appellant's brief 54 N7, the double jeopardy quote, principle, quote, he relies on is a negative implication drawn from the impeachment judgment clause. See id at 812, 46 tac 47. Thus, he does not invoke our jurisdiction based on the explicit grant of immunity found in the double jeopardy clause. Nevertheless, we can exercise jurisdiction for two reasons. First, Midland Asphalt is distinguishable and does not require immunity to derive from an explicit textual source. Second, the theories of immunity former President Trump asserts are sufficient to satisfy Midland Asphalt under circuit precedent. A. Distinguishing Midland Asphalt. Midland Asphalt dealt with the third prong of the collateral order test in the context of criminal defendants who argued they were entitled to immediately appeal the denial of their motion to dismiss an indictment because the government had violated federal rule of criminal procedure 6E2's requirement of grand jury secrecy. 489 U.S. at 796. The Supreme Court held that an order is, quote, effectively unreviewable, end quote, on appeal, quote, only where the order at issue involves, quote, an asserted right, the legal and practical value of which would be destroyed if it were not vindicated before trial, end quote. Id at 799, quoting